Before we continue, I just want to bring this information to you, gentlemen. All evidence is taken is protected by public privilege as provided by the Constitution Act 1975 and first subject to the revision of the Legislative Council standing orders. Therefore, information you provide during this hearing is protected by law. You're protected against any action for what you say during this hearing, but if you go elsewhere and repeat the same thing, those comments may not be protected by this privilege. Any deliberate false evidence or misleading of the committee may be considered contempt of Parliament. All evidence is being recorded. You will provide a approved version of the transcript following the hearing. The transcript will only be made public and posted on the committee website. Just soon as Dr. Phil can hear us, we'll introduce him. Could you please, Sergeant, state your full name and workplace you're representing today, please, for recording?
Patrick Cook. I'm Director and Chair of Workplace Drug Testing Australasia.
Welcome, Mr. Cook.
I'm Scott Osborne. I'm Director and Chair of Workplace Drug Testing as a...
Welcome, gentlemen. Thank you.
Sorry, did I say Chair? I meant Treasurer.
One day. Okay. One day you get there. We'll work on Dr. Phil audio shortly. Can you hear us? No, you can't hear us still. We'll get to him as soon as the technical issue has been sorted out. Would you gentlemen like to have an opening statement?
Yes, please.
Thank you.
Yeah. On behalf of members of Workplace Drug Testing Australasia, we thank you for your invitation to present to the committee. WDTA is committed to professional standards of testing in Australia and New Zealand, as well as advancing the field through advocacy, education and conduct testing at the highest standards of integrity, accuracy and fairness. Our association represents more than 75% of the industry, including testing organisations, product suppliers and consultants. WDTA see workplace drug testing as one tool to ensure the safety of a workplace. The basis of workplace safety is that an employer must provide a safe work environment for employees, and employees must attend their workplace capable of performing their work functions. Safety systems around drug and alcohol testing are well established in Australia and New Zealand. Many businesses have mature and well-developed programs designed to keep their businesses and workers safe and compliant within the well-established Australian and New Zealand standards for testing. These Australian and New Zealand standards cover technical aspects of testing, including ensuring a fair and consistent process, privacy of the person being tested, with accurate and effective testing. In addition, these standards, there is an auditing and an accreditation regime conducted by the National Association of Testing Authorities, NATA. This ensures compliance to the standards. In Australia, workplace drug testing as a safety system is well established and well managed when it is performed by a professional, accredited testing organisation such as our members. WDTA firmly believe that the robust process that is already in place cover all prescribed and non-prescribed medications that may impact safety. Medicinal cannabis should not be treated medicinal cannabis should be treated as any other substance that, even if taken legitimately, might impact on the safety of a workplace. The use of medicinal cannabis cannot be ignored because of potential physiological effects that might impact safety. Therefore, if identified, employers must be obligated to investigate the potential effect on safety and take appropriate steps to ensure the safety of the workplace. We have offered in our submission mechanisms for ensuring that donor workers who are tested with concentrations of various medications, including medicinal cannabis, are properly managed through referral to medical review and a genuine search for a design of an appropriate and safe system of work. WDTA advocates that workplace drug testing should be conducted by professional organisations that are independent to the workplace, that are suitably qualified and accredited, such as members of our association. We thank you again for your invitation, and we would be delighted to assist with any further questions from the committee. Thank you, Chair.
Thank you, Mr. Cook. Mr. Osborne, do you want to make comments at all?
No.
Thank you. Dr. Phil Tynan, you actually can hear us now. I think you just joined us again. Dr. Phil Tynan, can you hear me?
Doesn't seem to be.
Can you hear us? Oh, okay, that's right. We'll continue. Oh, thank you. We can hear him, but I don't think he can hear us. Thank you, gentlemen, for this submission. So the workplace drug testing, do you actually analyse the drugs at all, or you don't? You just do policies?
No. We're an association of testing groups as well as suppliers and
Okay.
consultants.
Just from your expertise, and I think there's a few of people on your panel and work. Is it cannabis, this all cannabis, THC and CBD? Can you actually analyse percentage or proportion of THC in the drugs? Is that possible?
I would like to have Phil Tynan, Dr. Phil Tynan, to answer that question, to be honest, but we test for the presence of THC in the drug, not for CBD.
Yeah.
So CBD by itself is not actually found by our testing regimes. So it's the THC component of the medicinal cannabis that is tested and seen and analysed.
You can analyse the percentage of THC in the substance.
So the devices we use on site, so they're purely a screening
Yes.
device. They get a dichotomous result above a particular concentration, which is set in the Australian standard. So the levels that we're testing for on site are above 15 nanograms per mil, for example, for oral fluid. So the whole point there is that we're simply identifying the presence of a drug above a particular concentration. From there, if we identify it above that, then it gets referred to an analytical laboratory, which then provides a more of a qualitative result, so numbers and also some commentary underneath.
So what I just want to know, what is the time frame to get result back after it's been tested positive of THC, to get the actual percentage in the result?
Again, that's a sort of a toxicology question.
Yep.
You know, we've got experience, I guess, but we can't answer as a toxicologist, but it depends what type of sample you take. So if you are taking an oral fluid sample, you've got a detection period for THC specifically, let's say, of between 4 hours to 14 hours, something like that. But if it's a urine sample that you've taken, then you've got a longer window of detection on a urine sample.
So from my perspective, I also run a testing organisation. The 4 to 14, maybe 24. 24's
Yeah.
pretty far out there, the far end of extreme. I thought your question might have been more about how long before we get a result back from a laboratory. So generally speaking, Australia-wide, we're talking around about 3 days. Can go as far as 5 days if you're talking a very remote area. In a metropolitan area, typically we're getting a result back within sort of probably a day and a half to 2 days from the analytical
Sorry, it was
laboratory.
turnaround time of the late. My apologies.
Also,
Sorry.
Dr. Cook, Patrick, you mentioned in relation to medicinal cannabis, to be treated the same, and you said there's impairment having the effect similar to other drugs. Could you just expand on that in relation to the impairment of medicinal cannabis?
Again, that's sort of if we talk about workplace drug testing Australasia, which is what we're here for, that's sort of slightly outside of our wheelhouse, let's say. But to expand a little bit on we're not testing for impairment. We're detecting the presence of THC, so in medicinal cannabis, for instance. Yes.
You said we should treat this the same as other drugs.
Correct. Yes. So we have a process involved in the testing regime. So we do a screen, as a testing organisation does a screen. If that screen produces what we call a non-negative result, In other words, that it's not truly a negative. We then refer that sample on to a laboratory for detecting the analytical component of that to give a firm positive to that sample.
Thank you.
So that period, that turnaround time period, does mean that the worker is generally stood down during that period unless there's other arrangements in place for Safework method while that's occurring.
Yeah.
But it's purely as a make-safe provision until we can get an proper analytical result back.
That comes back to the individual workplace policy of how the employer organisation has developed their policy.
Okay, thank you. Dr. Phillip, can you hear me still? Yet? No? Okay.
I think he's on the phone to
Dr.
Lillian.
Ryan, you want to?
Yeah.
Yeah, thanks, Mr. Cook, Mr. Osborne, thanks so much. How widespread is the use of workplace drug testing, and where is it most common on an industry-by-industry basis?
Yeah, I might let Scott answer that question.
I was hoping to leave it to Patrick. That's a big unknown at this point. As an association, we're looking to actually do a survey of our members and then try and extrapolate to what's happening in the industry. We test, so in my other role, we test about 400 different organisations, and that ranges from as innocuous as a retail music shop all the way through to rail, that kind of testing under the ONTRA, Office of National Rail Safety Regulator, those sort of guidelines. So it's a really broad shop, and often they'll contact us because they've identified a white crystal substance in a bag behind the stack of timber down the back. And so they contact us and ask us to test on that basis going forward, and then setting up a random program to ensure that it's prevented from the workplace. But yeah, at this point, it's a fairly difficult question to answer.
Which gets to our next question about how does it get started or initiated? Like, why do employers come to you? Is it because they're in an industry that has a set of standards or a degree of regulation that says they need to do this? Or is it because they've found they've had an accident in the workplace where they suspect someone's been under the influence of alcohol or other drugs, or they've found some substances they want?
It's both.
It's in short, all of the above.
It's definitely both. And the way it gets implemented is, in terms of developing policy first. We, as professional organisation, we just don't come in on the say-so of, hey, I want you to test my workers.
So do you require organisations to have a policy?
We request, we don't require, we have to request that, do you have a workplace policy in place first around this?
Right.
Because that's an important part. And we found over the years, and I've been in this industry for a few years now, that following the workplace policy should be involved the employees as well as the employers to develop that policy, and then an educational process through the workplace to implement that policy before testing even begins.
Sort of gets to one of the other questions I was going to ask, which was when you provide reports back or guidance back to employers about what you've found, do you draw the distinction between your ability to detect the presence of a substance versus not being able to give guidance as to whether that presence has led to any sort of impairment? Do you provide that to employers, or do you put the obligation on them to know that, have that knowledge themselves?
No. We test for the presence. So all of our systems, we're testing for the presence of a drug.
I understand what your testing does. Like, when you communicate back, what do you say that you can and can't do?
Try and answer that.
So the laboratory reports as they come back are pretty prescriptive in what they have to say. They comply with the standard, so there's certain things that they are required to say. Generally speaking, from there, in my role as Group GM for a testing organisation, I get asked, so what's that mean? And
what does this mean? What do you say when they say, what does this mean?
It's always going to be along the lines of, this is an indicator that there's drugs present. Now this is a HR matter for a conversation with the worker about, when did they take the drug? There's a whole range of questions along a very broad sort of set of subjects there. So when I do policy review, which I do a substantial amount for a lot of organisations, that's the number one thing I'm nailing is this isn't sort of just a closed process now. We've got this result. Now we need to understand what's going on. Is the worker safe? What are they being treated for, if it's appropriate to ask that question? They might volunteer. Then it's a case of, okay, so you're taking, let's move away from medicinal cannabis. You're taking a strong opiate or opioid for really bad back pain. We don't want you to go back into work into a place where you're likely to further injure that. Let's figure out a way to manufacture some duties here that are not going to further exacerbate that back pain until such time as this is all resolved. So there's a much bigger conversation. There's a testing question, and then there's a what do we do with that result
management
question.
Yep.
And that's part of the medical review officer as well.
Thank
role.
you. David?
Thanks, Chair. Yep. Can I just be clear? WTA is the body that actually, it's the advocacy body or the peak body for the people who sell goods or services in the testing industry, drug testing industry. Is that correct?
Yep.
Okay.
And we're fundamentally focused on improving the professionalism and the
Professional
standards of
Sure. So when you say in your submission that it should be, you recommend strongly that it should be mandatory that there's drug testing in all workplaces, that's kind of pretty strong self-interest there, isn't there?
Totally. I would say that that's a fair characterisation. However, we're in this industry because we believe in that this is an important safety system.
Okay. So can I go to your submission where you say, and it's picking up on some questions from Mr. Batchelor before, you say workplace AOD testing is not and has never been about detecting impairment. Rather, it serves as a risk mitigation tool, providing an objective measure to reinforce an employer's AOD testing policy. Now, if we're all agreed that you can't test for impairment, and impairment is the source of risk, how on earth can the presence of THC be an objective measure?
It's an objective measure of the presence of the drug.
That's all it is. It actually has nothing to do with impairment.
You can't draw a direct line, but it's an indicator that there's further investigation required.
Right. So, I notice you have a very sort of, how can I call it, conservative view of latency. Because we've obviously got a whole lot of people, including from Swinburne, from Lambert, from Sydney University, who all say that in fact flow testing, and the police themselves say flow testing results swabs can detect THC more than a week after it's been consumed, particularly
oral fluid.
Yes, on oral fluid.
Okay.
You
I'm not
dispute that?
qualified to answer that. I don't agree, but I'm not qualified in that.
Well, we have multiple submissions that say exactly
I understand
that.
I've read
Also that there's a 20% false positive and 20% false negative associated with the standard flow test.
Hence the need for analysis in the laboratory.
Right. Okay. So do your members actually sell anything that measures impairment rather than just the presence of drugs?
No, we don't.
Right. So it's just a black hole, really.
So there's no scientifically reliable way, as far as I'm aware,
Right.
as far as I'm aware within the scope of my skills and abilities, but to test for impairment in a blanket sense.
Okay, so things like Druid or can test, they're not on your radar.
The Druid in Europe, the workplace, the driver
Yeah.
system, yes, of
Well,
course
it's not
it's
a
on
driver system. It's actually used in industry.
Yes. When you
Primarily
say
it's
Druid,
actually.
you mean the Druid program that was
Study.
done in the USA?
Correct. I'm not talking about the wood-loving priests. No.
No.
But you don't have any view on that? I guess because I'm looking at the logic in your submission, and it basically seems to me you're saying that the only way in which you're saying someone can be not guilty of impairment if they've got no THC traces in their blood. Otherwise, you have to assume that they need to be the subject of further investigation and such like, and which seems to me fundamentally discriminatory.
So when we develop policy with clients, we say to them, this is one tool. If you are still concerned about impairment, then you need to, for that person. So even if the test is negative, you still need to, they've come on your radar for a particular reason. So if we're talking upon suspicion or post-incident testing or that sort of thing, they've come on your radar for some reason. You now need to either assess their ability to, is there something else going on here? Is there, do we need to be looking generally at their safety in the workplace in a general sense? Because they've come on your radar. Why did they come on your radar?
Because they may have had traces of THC in their system.
Well, okay, so they may, that might be as part of a random program, but generally speaking, if you're talking upon suspicion or after an incident, they've come on your radar because of the incident, or they've come on your radar because of a suspicion that there's something going on there. Because someone's come to you and actually said, hey, look, this person's acting erratically, out of character behaviours. I train in this particular
You're saying
area.
it should be mandatory drug testing.
Sorry?
You're saying in your advocacy, in
Absolutely.
your paper, that it should be mandatory drug
Yeah,
testing
for
in all workplaces.
random testing, that's right. But I'm saying is, if they come on.
Well, I mean,
Thank
sorry,
you.
Chair,
Thank you,
I've
Dave.
used my
That's
time.
right.
I think
Thank
I've made
you.
my point.
We've got a bit of technical issue with Dr. Phil Tynan. So, Dr. Tynan, we would like to make an opening statement. I know you probably can't hear us on the screen, but can you, or you on the phone?
I can hear you on the phone, but I do apologise for this. I have no idea what's happened. Anyway, look, as I said, I'd like to express my appreciation for the opportunity to address this august body on the topic of medicinal cannabis. I'm Dr. Phil Tynan, the National Chief Toxicologist for Safework Health, Australia's largest private workplace laboratory drug analytical service and collection agency, and I'm a retired chemical pathologist with over 30 years' experience in the field. Now, I was just going to note that the clinical role of medicinal cannabis isn't fully clarified. Evidence supports its use in treating chronic non-cancer neuropathic pain, MS-related spasticity, chemotherapy-induced nausea and vomiting, and some possible but short-term utility does exist with dealing with sleep deprivation due to chronic pain, obstructive sleep apnea, and fibromyalgia. Now, as with any medicine, there are obviously trade-offs, benefits versus side effects. The important thing is to realise that cannabis-associated impairment is real. In fact, on-road driving studies show that cannabis impairment from low-dose cannabis is roughly equivalent to a BAC of about 0.02, can be higher with higher doses, or the equivalent of, if you like, one night's sleep deprivation, or the hangover that we get from 10 plus milligram overnight dose of Valium. And that Carnita et al. In 2023 found that cannabis use during or just prior to work was associated with an almost twofold increased risk of experiencing workplace injury. Now, Arnold in 2020 showed us that THC in medicinal cannabis equivalent doses causes significant impairment up to about 4 to 6 hours post-dose. Edie et al. In 2021 showed that the neurocognitive impairment from medicinal cannabis, most of it clears after about 4 hours or so, dependent on the duration. Intensity was dependent on the dose. Unfortunately, they only address chronic non-cancer pain and spasticity, so we don't know whether this really applies for anxiety, depression, or insomnia. We should also note that, unfortunately, at the moment, there are no guidelines for medicinal cannabis dosing, in other words, how much people should be taking. But from the data, it appears that a worker taking medicinal cannabis of category 2 or higher, in other words, greater than 2% THC to CBD ratio, probably should refrain from use at work and ideally abstain for up to 8 hours prior to working. But for category 1 preparations, which are essentially nearly pure CBD oils, then there's no requirement for any restriction at all, because unlike THC, CBD, cannabidiol, has no substantial impairment. An important thing is that drug testing is a critical factor in managing workplace drug use. I mean, Osborne in 2003 showed that there's a statistically significant link between the frequency of drug testing and dropping drug use rates and workplace injury costs. Miller, Zalosh, and Spice in 2007 showed that for every dollar we invest in workplace alcohol and drug prevention, we save $26 in the workplace accident expenses. Now, the current drug testing regime and the legislative framework we've got is adequate to deal with this issue. Workplace drug testing is regulated, as we all know, by the current Australian drug testing standard, which is AS 4308-2023 for urine, and the sister standard AS 4760-2019 for oral fluid. Of course, these standards ensure that the testing process is robust and the results are accurate and scientifically verifiable. The entire drug testing process is overseen through a really stringent auditing process by our statutory accrediting authority, which of course is NATA, the National Association of Testing Authorities. And moreover, the fairness and robustness of worksite drug testing is ensured by the fact that we're subject to the rulings of the Fair Work Commission. My point is that workplace drug testing should not and cannot be used to enforce legitimacy. The overriding concern we should have is to focus on potential impairment, and therefore test results shouldn't be treated as unequivocal proof of impairment. They're not, but actually as red flags, this is for this drug, red flags for potential impairment. And so therefore in this context, urine testing is, although it's valuable for many other drugs, is unhelpful here because the detection window is 3 to 5 days for one-off use, which is clearly useless, whereas oral fluid detection window is a lot better. It's up to about 12 hours, very rarely extended to 16 plus hours. And this better reflects impairment from cannabis usage. And therefore in many situations, you can use random oral fluid testing to determine if the person's affected. In other words, if it's not affected, the worker is likely unaffected. My closing point is that medicinal cannabis is not a unique product and should be treated legislatively and in the actual workplace with the same professional rigour as we routinely handle other potential impairing medications like, well, say, the opioid analgesics or benzodiazepine sedatives, which clearly have a similar workplace impact. Thank you.
Thank you, Doctor. I'm happy you stay on the phone if you like, because we can't get you. Yep. Dr. Mansfield, would you like to continue?
Thank you, and thank you for appearing today. And I might just continue on from where Mr. Eddershank left off. In your submission, and I know, sorry, you both have separate submissions, but in your submission you indicated that workplace testing, you made a quite definitive statement about that workplace testing does reduce injury risks. And the evidence that I think some of it was referred to just now that you've relied on to make that statement, there were two studies that when you actually read the studies, they're particularly old studies. So they were looking at interventions that were in the sort of mid-90s, mid to late 90s in the US, and both of them were in individual workplaces. And the methodology, there's some questions about the relationship between the intervention and the outcomes. So I'm just wondering, do you have any other more up-to-date evidence that demonstrates the role of workplace drug testing in preventing injury? And I'm not talking about, no doubt there's a link between impairment and some of the effects of some substances in creating impairment and the safety risk, but testing, the role of testing in preventing injury, do you have any strong evidence to support that?
Easy response is no. There's no current studies that I'm aware of. I keep looking for. Phil might have. I think he took his breath there. But yeah, there's no. As far as I'm aware, there's no current studies that have been done on this. That would be very good to see. Some studies in that area. Yeah.
Okay. Some work done in the Portuguese rail service from last decade, where they demonstrated that by imposing a stringent drug testing policy, among other factors, they actually decreased the workplace accident rate. But the applicability to the general workplace is, I suppose, to some extent open to question.
Certainly, there's was a flurry of studies sort of in that 90s, early 2000s period. I think possibly here in Australia, particularly related here in Victoria to the introduction of roadside drug testing. I think that was sort of the last big flurry of such studies. So, yeah, that's...
Okay. And so I guess I'm just curious, as to the conclusions you've drawn, that it, you've been very confident in your or you've made quite a strong statement that it does prevent workplace injury. So I'm just wondering how you can come to that conclusion given we don't have a strong evidence base to support that.
Simply.
I think we do have some evidence when dealing with drugs like methamphetamines and amphetamines. It's quite clear there are problems. And if you look at the Quest data, there does appear to be a correlation with both frequency of testing and the drive to reduce workplace accidents. And this is the Quest drug testing data from America, which is somewhat more recent. Apropos cannabis, again, that's a more recent issue, and it's rather harder to determine because, again, if you're relying on stuff like urine, you really can't tell whether the person's taken it recently or not. So urine should be excluded. When it's dealing with oral fluid, that certainly would give you some indication of recent effects. I think we can be pretty certain that with amphetamine-type stimulants, there does appear to be a positive effect, particularly with cocaine. And just speaking as a clinician, we do actually tend to, when you're dealing with individual cases as opposed to generic cases, drug testing and the actual quantitative drug levels are very useful in assessing potential impairment at work. Tsiolkovsky's work with opiates, for example, he demonstrated that codeine, if you alter the dosing by 50%, you do in fact run a substantial impairment risk, at least for a couple of days until you get an adaptation effect. So, I think we can quote data for the opiates, for amphetamines, but not for cannabis, and certainly not for recently for Australia.
Okay. Thank you. Richard?
Thank you, Chair. Thank you, gentlemen. Just want to acknowledge that every industry needs an association, and so you do actually play an important role in the industry and keeping our workplaces safe. So please don't take offence at my questions as a result. As part of your advocacy, your correct advocacy, are you, as part of those activities, alerting parts of the industry that are not currently doing widespread testing to the dangers of that they may incur, and then extending testing into a wider range of industries?
Correct, yes. That's one of our fundamentals of our advocacy, is to try and get more and more businesses looking at doing workplace drug and alcohol testing, but more importantly, the broader aspect of safety in the workplace.
Yeah, and that would include perhaps more white collar type industries as well.
Correct.
Yeah.
Yes.
And where the effect of impairment would be, look at it in a heavy machinery industry, the cause and effect are very clear and tragic. In a white collar industry, they push the wrong button on a spreadsheet. So, how do you reconcile the importance in that environment?
Yes.
Do you want to do it? Or?
So, I'm happy. So, in general, sort of people who are in a white collar sort of perspective are often making decisions. So I'm not talking, an accounting office, for example, but people who are administering sort of in a high risk industry around high voltage electricity or something like that, for example. The people who are in the white collar roles are still making decisions that can impact the safety of the worker. So you don't want them making those decisions if they're not in full possession of their...
There's also the issue that codeine dependency, and this is what's provoked the TGA to change the regulations about over-the-counter codeine use. Codeine dependency is highest among white-collar, socially well-adjusted individuals, and the evidence is that you do get impairment of performance, not universally so. If it's a long-term usage, people often will adapt, especially if it's to mitigate the effects of chronic pain. But there certainly is evidence that you can have subpar performance even among white-collar workers who are misusing opiates for whatever reason. So I think that's a point. The other point is that we must consider that in Australia, we have quite a high, for example, death rate among our miners, which is a bit atypical given our OECD ranking. And one of the significant factors, apart from fatigue, is drug use. So I think we really shouldn't underplay the importance of trying to control drug use, not preventing people from having fun on the weekend, but actually ensuring that the workplace is maintained as a safe environment. And a large factor of that's going to be workplace drug testing. Even if you're a white collar worker, you can make major disasters, by being affected, and quite unintentionally. There can be problems from that. Opiates are a major issue, and I would suggest cannabis could be a factor as well.
Okay, thank you.
And I guess as the follow-up to that, I think, and again, I think in heavy industry, it's not contestable to me, but in white-collar industries, does the association have a view of where the employer and safety is one area of interests, but where does the association view civil liberties in terms of the right of the individual? If there's not a direct correlation between their impairment and their role and the potential for a creeping intrusion, which, as is pointed out, you could be accused of having a vested interest in creeping that. So where does civil liberties is where I'm interested in.
I guess that's got to be one of the major parts of our association, is that we've got to respect the individual's privacy, civil liberties, and not be discriminatory against anybody in terms of what we're trying to advocate for.
But does that also include the right not to be tested?
Absolutely, it includes, but that should be then covered by a workplace policy, as in what happens if I refuse to be tested. You can't force somebody to be tested. That's not what we're advocating. But in the policy, there should be some sort of section in the policy. Well, what do we do if a employee refuses test? And that should be prescriptive in their workplace policy.
As opposed to an entitlement, an implicit common law entitlement not to be tested.
In terms of sort of wide consultation on a policy, so I do a heap of policy work, and in that regard, it's always around that initial consultation, workforce-wide. Appreciate there's a power dynamic, but there still needs to be that consultation, and then there needs to be, widespread publishing of the policy and procedures, etc., associated with that, followed by a strong sort of education process prior to any of sort of testing started. So here in Victoria, I recently did one where they also put out a FAQ with the ability to ask questions anonymously, self-declare. There's a whole, a well sort of developed program needs to have all of those elements in place. And then sort of testing is one element, and then what happens after that. So whenever I'm doing policy review, I'm sort of always saying, you've got to refer out at the end into a sort of a more HR type thing. Separate the testing from what do we do after that. So they're two separate issues, so that we've got professionals who are well qualified, medical review officers involved where necessary, that are, highly trained, part of the AMROA framework, so that whole process then is properly managed in a non-discriminatory way. I think where I see it really going wrong, and we do see this on occasion, is organisations that they'll get a screening result and they'll just terminate the person off and then in one case they refused to pay my bill because they went to Fair Work and lost, of course, which was totally contrary to all of my advice and all of the support. So we are really focused on ensuring that, testing is one element, but at the other end, let's get the outcome, to be the right outcome for that worker.
Thank you. Just minding of time, Rachel, you have some questions?
Thank you, Chair. And I actually have quite a few questions that, if you're happy, I may put them to you on notice, if that's
Sure.
okay, just being mindful of the time.
Yes,
yeah,
for
thank
sure,
you.
yeah.
And just going off what my colleague was talking about in relation to balancing workers' right with that of discrimination, I mean, you believe your model for medication use, including the use of medicinal cannabis, strikes that balance. And in your submission, you talk quite a lot about testing procedures, but there is not a lot of reference to preventing discrimination. Can we talk a little bit about that discrepancy? And I'm just going off the back of what you were just talking of.
Yep.
Yeah. So we're testing organisations by and large, and our predominant role is to, in essence, perform scientific testing, provide a result. It just so happens that within my organisation I do a lot of policy review, and part of that is sort of I get asked all sorts of questions, and actually I did do a separate submission. I get asked a lot of questions about these things, not in Workplace Drug Testing Australia, but in terms of my other organisation. So I, from a Workplace Drug Testing Australasia perspective, my submission is very much about the testing processes. But from my other hat, I'm very focused on saying, hey, keep them separate. These are two different issues. One is finding out what's going on as much as you can within the limitations of technology and all the rest of it. And then having an adult conversation with your staff afterwards to figure out, okay, so we've got this situation, what do we do from here? So my submission as part of the WDTA was limited to really largely testing.
And you would say that would be captured in, say, that policy framework, and then, it would become a matter then for a referral for medical review, potentially with the HR officer within that,
correct.
Employer's purview.
Mostly within the policy review that I do, it is very much around, okay, here's a testing policy and procedure, and I'm not going to lie, a lot of clients then want to go straight to termination. They find something, terminate the person, get rid of them out of my organisation, it's easy, right? And I'm constantly working with them to educate them to say, no, you've got a testing policy and procedure, then hand it over to the professionals in the human resources element, who are then able to conduct an appropriate investigation that's they're the professionals dealing with non-discrimination, all of those sort of things. So very much that's sort of the model I advocate for. As with anyone, when you're working with people who might be a small mum and dad type business, there's an education process, and even the data doesn't support termination for first offence in inverted commas. Actually indicates that will actually raise the likelihood of somebody actually taking drugs. I don't know what the psychosocial things are behind that, but that's what the data shows. It is an American study and it is probably 30 years old, but nevertheless, that's the data. So from my perspective, dealing with testing is one issue, dealing with, and highly regulated under the National Association of Testing Authorities. But then you've also got a legislative and case law and all the rest of it that kind of deals with the other end of it, which is discrimination and privacy and ensuring that you're not asking questions that you're not entitled to ask. So a whole range of things there. Sorry, I chewed up your time.
That's okay.
Apologies.
And I did have some questions for Dr. Tynan, but if he's okay for me to put them on notice to him, that would be ideal. Thank you.
Lee and Dr. Heath, do you mind putting your question on notice? Is that okay to monitor the time?
That's fine.
Dr. Heath, happy. Thank you. Dr. Tynan and Patrick and Scott, thank you so much for coming in today. And we'll definitely have some questions put on notice to you.
Okay.
Regarding Dr. Tynan, are you happy to review the transcript today, which will be provided to you? And if anything else you want to add, please do add on, and we'll give some questions on those to you. Is that okay?
Absolutely, sir.
Okay.
Thank you.
Yep, thank you.
Thank you.
Again, thank you, Dr. Tynan, and thank you, gentlemen, for coming in. Let's suspend the tape. Thank you.